Hello, everybody, and welcome to our second Power to the People webinar. Tonight's webinar is on the power of Indian sovereignty. My name is Mark Gage, and I'm the Director of Publishing for the Center for Civic Education. I'll be serving as the facilitator of this event. This webinar will last about an hour and a half until 9 p.m. Eastern. Our sponsors for Power to the People are the Center for Civic Education, Kansas State University, the Johnson County First Amendment Foundation, and the Indiana Bar Foundation. Thank you so much, sponsors. We could not do this webinar series without you. And our scholars for tonight are Robert S. Lemming, Director of the We the People programs for the Center for Civic Education, and Thomas Vance, Director of the Center for Social Studies Education at Kansas State University. They'll be moderating the event tonight. And now, I would like to introduce David E. Wilkins, the E. Claiborne Robins Distinguished Professor in Leadership Studies at the University of Richmond. David Wilkins is a citizen of the Lumbee Nation of North Carolina. He earned his PhD in Political Science, Comparative Politics, from the University of North Carolina, Chapel Hill. He concentrates much of his work on Native politics and governance, with particular attention on the transformations that Indigenous governments have both coercively and voluntarily engaged in from pre-colonial times to the present. The concepts of native sovereignty, self-determination, and diplomacy are at the heart of Wilkins's research and teaching. He has been a visiting professor at Dartmouth College, Harvard University, and Wake Forest University. Welcome to everyone, and I hope you enjoy tonight's presentation. And with that, I'll turn it over to Robert S. Lemming. Bob.
Welcome, everybody. I'd just like to say congratulations for being here tonight. I'm so looking forward to this discussion tonight. Professor Wilkins and I we've known each other for over 10 years and used to do seminars on the Navajo Nation. So I know you're going to enjoy it. So jump in with questions when you need to. And Tommy, would you like to say something?
I'll just, again, add my welcome to everybody. Really looking forward to this. I've heard a lot about Professor Wilkins, and Bob over the years has told me so many great things, and so I'm really looking forward tonight. And I want to thank Professor Wilkins for being a part of these webinars.
Thank you, Tom. And Professor Wilkins, you can go ahead and start. Thank you so much.
Thank you very much, Mark, and I want to thank Bob Lemming and Tom Vance for all of your support in putting this together and for having me join you this evening. It's my pleasure to be here. I wish I could see everybody's faces, and I wish we could do this in person, but COVID-19 simply won't allow us to do that these days. So we'll do it using this format. I had previously asked Mark to upload a number of handouts that normally I would share with you in person, and all those are available somewhere on the site that Mark and Tom can tell you about. And they provide some of the detailed information that we won't be able to get to tonight, but they deal, one sheet, for example, gives a number of definitions of the most important concept that we're talking about this evening, which is the concept of tribal sovereignty, of native sovereignty. I wanted to begin actually with two of those definitions because they really sort of set the stage for what I want to cover tonight. And what the handout does is it provides definitions from a native perspective, definitions from the US Supreme Court's perspective, and definitions from other scholars who have grappled with the concept, because it's a universal political concept, of course, this the idea of sovereignty. But the definition that, there are two definitions that are on the handout that I most closely adhere to. The first one comes from my mentor, a philosopher by the name of Vine Deloria Jr., arguably the greatest native intellectual of our time. He, in one of his writings, had this to say about the concept of indigenous sovereignty. He said, continued cultural integrity, more so than a political powers, and to the degree that a tribal nation loses its sense of cultural identity, to that degree it suffers a loss of sovereignty. Cultural integrity involves a commitment to a central and easily understood purpose that motivates a group of people, enables them to form efficient, albeit informal social institutions, and provides them a clear identity which cannot be eroded away by the passage of events. Sovereignty, then, revolves around the manner in which traditions are developed, sustained, and transformed to confront new conditions. It involves most of all a strong sense of community discipline and a degree of self-containment and pride that transcends all objective codes, rules, and regulations. Vine used to emphasize the idea of sovereignty as not so much a political or legal concept, but one of a cultural concept. And so another definition that I like, and it's a much shorter one, this comes actually from an Algerian psychiatrist, Frantz Fanon, and he had this to say about how the African Algerians understood sovereignty. And I think indigenous peoples the world over could relate to this. And Fanon said, the African peoples were quick to realize that dignity and sovereignty were exact equivalents. And in fact, a free people living in dignity is a sovereign people. And I think that's quite powerful and quite beautiful. It resonates closely with me and many of the indigenous peoples that I engage with. Now, the title I was given to work with, The Power of Sovereignty, is a good one, as sovereignty really is the foundational concept that all indigenous peoples embrace. And as you can see from the one handout, if you ask 10 different Native politicians, academics, US politicians, Supreme Court justices, you're going to get a variety of definitions. But the two I shared with you, I think, are quite powerful, and they certainly resonate with indigenous peoples. And they reflect the idea that sovereignty is our soul, and that the power of self-determination is the muscle that protects our sovereign souls. And the central point to remember is that we were, as Native peoples, and remain the original sovereigns in the Americas. Our sovereignty predated that of the United States and is neither derived from the United States or state constitutions, and is not protected by those documents as well. But our sovereignty is also, of course, subject to constraints that other governments don't have to worry about. And this is one of the fundamental problems that indigenous peoples face in our current political and legal relationship with local governments, state governments, and of course, the federal government. And I'll just share with you one quick quote that sort of highlights the attitude that some federal policymakers think about Native sovereignty. This comes from a case in 1978 called United States versus Wheeler. And here's what the court said there in 1978. The sovereignty that the Indian tribes retain is of a unique and limited character. It exists only at the sufferance of Congress and is subject to complete defeasance. In other words, it could be wiped out tomorrow. It could be declared null and void should the Congress or the court or a president decide to do that. So our sovereignty, as powerful as it is, and despite everything that we've endured, it is still subject to being eradicated, to being disavowed by the federal government. So I talk about this, I teach about this, I work with this concept all the time. And so it's going to overarch everything that we're talking about this evening. So when I received the flyer and then the call from Bob describing our webinar, I was interested when he first sent the flyer to me because it has a statement that Charles Wilkinson, a prominent non-Indian law professor, said. And here's what Wilkinson said. He said, there are three branches of sovereignty within the American constitutional system: the United States, the states, and the Indian tribes. Now that sounds reasonable, doesn't it? But as reasonable as it sounds, it's not accurate. Native nations are not, in fact, US constitutional creatures, because our pre-existence, was long before there was a US Constitution. And we were not parties when the United States was developing its Constitution. We were not parties to that conversation. And we have never been formally incorporated into that document, even though we are certainly mentioned in the Constitution. But being mentioned in a document does not mean that you are formally incorporated from a constitutional perspective. And this is a critical fact that confuses many Americans. Everybody simply assumes that all individuals and all groups in the United States are subject to the US Constitution. And that is simply not the case when it comes to Native nations, because of our original sovereignty and the fact that we have never been constitutionally incorporated. So I want to share a couple of quotes with you from key documents that I like to introduce when I'm teaching a class to my freshman students, and sometimes even my upper class students, to give you some idea of how confusing and exciting the study of indigenous sovereignty and Native governments is. And I want to begin with a statement from the US Declaration of Independence. And we all know what that document was about. It's a very powerful document, a critically important document from a democratic perspective. But here's the one clause that mentions American Indians. It says, "He, that is King George III, has excited domestic insurrections amongst us and has endeavored to bring on the inhabitants of our frontiers, the merciless Indian savages, whose known rule of warfare is an undistinguished destruction of all ages, sexes, and conditions." Now, if you're like me, that's a pretty powerful and pretty damning statement that Jefferson said or wrote in that document. And it's one that always is in the back of my mind when I'm talking about the rule of law, when I'm talking about democracy. And yet 2 years later, in 1778, the United States signed its first formal written treaty with a native nation. And this was the Delaware people of what became Delaware. And here's what Article 6 in the 1778 treaty said regarding the Delaware and their relationship with the United States. And it says, "As long as the said Delaware nation shall abide by and hold fast the chain of friendship now entered into, and it is further agreed on between the contracting parties, should it for the future be found conducive for the mutual interests of both parties, to invite any other tribes who have been friends to the interests of the United States to join the present confederation and to form a state, whereof the Delaware nation shall be the head and have a representation in Congress." So in 1776, we were declared merciless savages who kill everything. 2 years later, the Delaware were invited to form an indigenous state and have representation in Congress. So what happened? What transpired within those 2 years? And this is what we get into when I'm teaching my classes. And then, of course, in the Constitution, we're mentioned in 2 clauses where the phrase "excluding Indians not taxed" is found. And because, of course, that makes sense. Most American Indians were not citizens in 1789. And so we couldn't be counted for purposes of congressional representation. The one clause where we are mentioned that it does matter and still matters to this day is found under within the powers of Congress, the enumerated powers of Congress. Section 8, Article 3 says, "The Congress shall have power to regulate commerce with foreign nations and among the several states and with the Indian tribes." Now, commerce is trade, right? Because the United States, of course, having just fought a global, a major revolution, was desperate, was financially strapped, and it needed to find a way to establish itself, to stabilize itself, and it wanted to engage in trade relations with Native peoples as a way to wean us away from the British, from the French, and from the Spanish. So this is the only clause in the Constitution that references us, and so the only power that the federal government has from a constitutional perspective is to engage in trade relations with Native peoples. And that's important to keep in mind as we go through what I'm going to be sharing with you. And then we come to 1866. There's an important case that year, a Supreme Court decision called the Kansas Indian case, in which the state of Kansas was attempting to tax the allotted lands of 3 tribes that lived within the borders of Kansas. But the Supreme Court shut the state down and said, you have no right to tax Indians. They are separate nations, they are sovereign nations. They have signed treaties with the federal government, and their relationship is at a national level. And here's what one clause that I want to share with you. It says, if they, the tribes, have outlived many things, they have not outlived the protection afforded by the Constitution, treaties, and laws of Congress. So there we have the Supreme Court acknowledging that we're outside the constitutional framework, and yet because of the treaties and because of the Commerce Clause, the Constitution was going to provide some measure of protection for Native peoples. Which brings me to the last sort of vignette that I want to share with you. And now we're jumping up to the 21st century. This was the Supreme Court decision in 2004 called United States versus Lara, L-A-R-A. And in this case, it's a double jeopardy case. It was a positive case for Native rights. But Clarence Thomas, who has not been a friend of Native peoples, of Native rights, or Native sovereignty, made a statement that I wanted to share with you because it shows how ambiguous and how inconstant the relationship is between the federal government and tribes. And here, Thomas was comparing the relationship between states and the federal government, and tribes and the federal government. And here's what he said. But the states, unlike the tribes, are part of a constitutional framework that allocates sovereignty between the state and federal governments, and specifically grants Congress authority to legislate with respect to them. The tribes, by contrast, are not part of this constitutional order, and their sovereignty is not guaranteed by it. So there you have a current sitting Supreme Court justice saying what Native peoples have long known, that despite our presence in the Commerce Clause, despite our treaties, the Constitution does not provide any kind of actual protection for Native rights, which is why some tribes have been terminated. Tribes can have their rights, their lands taken without just compensation. It's again, it points to the very fundamental weakness in the tension in the relationship between Native peoples and the federal government. So now let me tell you a little bit about my personal background so you'll know where I'm coming from and how I came to do what I do. I belong to the Lumbee Nation of North Carolina. We live mostly in North Carolina, and we exist as a quasi-recognized people. The state of North Carolina recognizes my tribe as a bona fide Native nation, but the Bureau of Indian Affairs, which services all recognized tribes, refuses to acknowledge us. And so we sort of exist, as I said, in a quasi-recognized status. Thus, I belong to and am a citizen of the Lumbee Nation of North Carolina, and I'm also a member of, I am a Wolf Clan, a member. And according to federal and state law, I also happen to be a citizen now of Virginia, since I live in Richmond, and a citizen of the United States. But it's my core citizenship in the Lumbee Nation that's crucial for our purposes. So a Native person has 3 layers of citizenship. We should be theoretically the most protected class of peoples in the country. And yet, because of our native citizenship, our core citizenship, our other citizenships only provide us with partial protections. That's something to keep in mind as we move forward. So my citizenship affirms that my nation, a collective of people united by shared cultural features and the belief in the right to territorial self-determination, we are extra-constitutional entities. That's a term that Vine Deloria coined, and it's still accurate today. We exist outside the framework of the US Constitution and of state constitutions. Native nations long predated the formation of the US, with figures ranging now from anywhere from 12 to 50,000 years. And our rights as nations were therefore not created by, nor are they beholden to the US or state constitutions. And in fact, the US Constitution is largely inapplicable to the affairs of native nations inside their borders. And many state constitutions, in fact, 10 of the Western state constitutions, currently contain clauses in which the states agreed to expressly disclaim or disavow any jurisdiction or any taxation authority over natives or native lands within their borders. So what I'd like to do now is discuss a few specific topics that make this such a distinctive and dynamic area of study. And then at the end, we'll have time to move on and entertain some of your questions, and I'm looking forward to some of those. The relationship of Native nations to the federal and state governments, as Chief Justice John Marshall stated in 1831, in the case Cherokee Nation versus Georgia, is like no other in the world. Tribal nations, he said, have been legally and politically recognized by the federal courts as what Marshall termed domestic dependent nations, although in the very next case, which Marshall also wrote less than 3 months later, a case called Worcester versus Georgia, he said more accurately that tribes were distinct, independent political communities. The only thing that had changed between those two cases was the political context. And that is something we need to keep in mind. So which is it? Are we distinct and independent, or are we domestic dependent? It depends on who you're talking to at the federal level and on the US Supreme Court. Importantly, as I like to tell my students, the United States, in a very real sense, is itself a domestic dependent sovereign. It's domestic because, well, it's here on native land, arriving on our land long after we've been settled here, and it is dependent in the sense that it has split its sovereignty with the states, and in signing treaties with indigenous nations and other governments, recognize and reduce its sovereignty as well. In other words, no nation or state in the world today is a completely independent sovereign, including the mighty United States. Just look at the global economy, the US trade deficit, the McDonaldization of the world, and you can see what I'm saying. Native peoples appear, on the one hand, to have a similar political status as the small European states of San Marino, Monaco, and Liechtenstein, yet native powers of self-governance, so says the Supreme Court, may be erased at any time by the federal government. And tribal nations, with very few exceptions, seem to be forever mired in a state of political, legal, and economic dependency, except for a few well-off gaming tribes, and we'll talk a little bit about that later. Native nations, because of our extra-constitutional sovereign status, and because of our economic dependency, and this is what is fascinating and problematic about the indigenous situation, receive a variety of social services, including health and dental care and educational scholarships, and a number of tax exemptions and racial preferences that the smaller European states and American racial and ethnic minorities do not receive in terms of their relationship with the federal government. Native political and legal status is therefore a mixed bag. And let me try to make some sense of this ambivalent and paradoxical state of extra-constitutional affairs between indigenous nations and the United States by examining the actual relationship between Native nations and their citizens, who also happen to be American citizens, and the US by identifying several key concepts and principles that distinguish indigenous federal affairs. So I want to begin with a broad comparison. I'm a comparative political scientist by training, and so comparison is sort of in my blood. And I like to do this as a way to get my students to think about Native peoples not in isolation, but in comparison to other groups in the country. Native nations, First Nations, American Indian tribes, indigenous peoples, all these are names that are commonly used to describe Native peoples in the US. Along with other major racial and ethnic groups and women, are extremely vulnerable peoples. Native peoples, we number now 574 distinctive indigenous political entities in the US and Alaska. And I'm not counting Hawaii because that's a whole nother situation that would take in another webinar to talk about. We number a little over 6 million people, give or take a few thousand, and we inhabit some 278 separate homelands, also known as reservations, trust lands, pueblos, rancherias, and Alaska Native villages. Our lands total approximately 100 million acres. There are about 54 million acres in the lower 48 and another 48 million up in Alaska. And we have varying degrees of governmental jurisdiction over these lands. So we now control less than 2% of the original land holdings we did before Europeans first arrived. Brian DeLauria, who wrote his first book, was a bestseller called Custer Died for Your Sins. And I encourage you all to check that out if you get a chance. He was once asked by a reporter what Native peoples called America before Europeans arrived. And Vine said simply, "We called it ours." And I think that's a good answer. Like other racial ethnic groups, most Native nations are socioeconomically disadvantaged and politically quite powerless. Again, as I said, with the exception of a few gaming tribes. But the gaming tribes, of course, have been devastated because of COVID-19, and they're just now trying to get back on track, but they lost a lot of economic ground during this most recent shutdown. In other words, we share much in common with the classic definition of what constitutes a minority group. We have little real control of resources or power. We're distinguished racially and culturally. We have a sense of group solidarity. And we have common historical experiences of unequal or discriminatory treatment at the hands of the federal and state government. Plus, we have the added burden of having far too many sports teams, vehicles, and pieces of military hardware, like helicopters named after us. Despite these important socioeconomic similarities with minority groups, politically speaking, we are not minorities at all. We can more accurately be viewed as small nations. And we have fundamental differences with the other racial, ethnic, and gender groups in the country that make our relationship to the US and states a distinctive one rooted in diplomacy and politics. So let me share with you some of these major differences that distinguish us as Native peoples from other racial and ethnic and gender groups. First and most obviously, we are indigenous. We are the original peoples to this land, notwithstanding the Bering Strait theory that Thomas Jefferson preferred back in 1803. A second difference, tribal members can legally expatriate from their nations. If I wanted to, I could contact my tribe tomorrow and say, I no longer want to be recognized as a Lumbee, and they would disenroll me. And so I would no longer be viewed for legal or political or even cultural purposes as a Lumbee. Very few natives actually do that, but that is a choice that we have because while we have an ethnic status, we also have a political and legal status as members, as citizens of sovereign nations. Third, the concept of nationhood itself, which embraces the notion of communalism or the collective, recognize our cultural, political, and legal national rights. We are, in fact, as I said a little while ago, the only cultural racial group expressly identified in the US Constitution via the Commerce Clause and the Excluding Indians Not Taxed Clause. We know that African Americans were viewed by the, were determined by the phrase 3/5 of a person, right? Fourth, the fact of treaty making. This is a powerful difference. We are the only peoples native to the US who participated in signing treaties with the United States and foreign powers as well. We negotiated over 800 treaties between 1775 to 1871, although the United States Senate only ratified about 372 of those. And most of those treaties are still considered the law of the land. Even though provisions of every treaty have been violated, unless Congress passes an explicit law abrogating a treaty, the treaty itself survives, even if a provision is abrogated. And this is important because these treaties form the basis of our sovereign rights today. They provide us with a set of property, identity, and cultural rights that are inapplicable or unavailable to other Americans. Many treaties were, of course, land cession agreements in which the United States pledged to Native nations in exchange for the lands that were being ceded, that the U.S. would provide any number of services, protections, exemptions, and would respect all the sovereign rights that natives retained to themselves. And the McGirt decision that was just handed down in July of this summer is a powerful example of that. I put a short 2-page encyclopedia entry that I just wrote 2 weeks ago, in fact, up on the handouts that Mark Gage has put on, so that will be available for you to read, so you can get a sense of what the McGirt decision was. But it was a very powerful decision. That decision affirmed treaties that the Creeks had signed with the United States in 1832, 1833, 1856, and 1866. Creek Nation lands that had been guaranteed to them by these provisions, by these treaties, were reaffirmed as being Indian land, Indian country. So the state of Oklahoma, which had been acting as if it had criminal jurisdiction throughout Creek territory, was told by the Supreme Court in the McGirt decision by the slender read of a single vote, 5-4, that they no longer had criminal jurisdiction over crimes committed inside Creek territory. And the Creek, that precedent established by McGirt will likely now also cover the other so-called civilized tribes, the Chickasaw, the Cherokee, the Choctaw, and the Seminole, which means if you add all those lands up, we're talking about nearly 1/2 of Oklahoma has just been reaffirmed as a set of Indian reservations. A pretty powerful statement affirming the power of the sovereignty of those 5 sovereign nations. So in addition, there were another 50 or so agreements, because in 1871, the US unilaterally stopped making treaties, formal treaties, but they continued to make agreements with Native nations until 1914. And the only difference between a treaty and an agreement is that an agreement has to be ratified by the House as well as the Senate, whereas a treaty only has to be ratified by the Senate. Because states are expressly precluded from entering into treaties with other powers, does that mean that tribal sovereignty is stronger than that of the states? In this respect, the answer is yes, because we can sign treaties, or we did sign treaties, and states have never been allowed to sign treaties with other powers. And so this affirms that we have, as Native peoples, a political relationship with the federal government. One, it's that of a sovereign to a sovereign, or government to government. It's not a racially based relationship, although race certainly factors into the political dynamics of our intergovernmental relationships. And not that of an individual to the government. The treaties and agreements and their ongoing validity, though unfortunately not their consistent enforceability, recognize this government-to-government relationship. These sacred contracts, denominated by the U.S. Constitution as the supreme law of the land, according to the Constitution, provide the legal and political cornerstones of our distinctive political relationship to the United States. Now, here's a fifth way in which Native rights differ from those of other groups in the country. And this is a so-called trust relationship that is said to exist between tribal nations and the federal government. The trust relationship, along with treaties, is one of the cornerstone concepts that is unique to us and to no other groups in the country. It's not synonymous with treaties, though all treaties, either explicitly or implicitly, entailed a dimension of trust. Of course, the United States over time has developed a conflicting set of definitions of what trust means. But generally speaking, it is a moral argument steeped in the international law doctrine of trusteeship, which was first described in several Catholic papal bulls as early as the 15th and 16th centuries. In this articulation, the West claimed a protectorate obligation for all Native peoples. And this equates today with what is now termed a trustee-beneficiary relationship, with the federal government being the trustee and Native nations being the beneficiaries of that trust. Broadly, the trust doctrine is the legal and moral duty of the federal government to assist Native peoples in the protection of their remaining lands, resources, and rights. The federal government is to be held to the highest standards of good faith and honesty in its dealings with indigenous nations in all respects. Of course, this is all in theory, because in fact, the United States has frequently violated its own high standards whenever it's been in the national interest. Importantly, the trustee-beneficiary relationship differs fundamentally from the historically described, though never constitutionally or congressionally declared, guardian-ward relationship which some of you may have heard of before. Guardianship is a relationship that limits the personal rights of a ward, while trusteeship is a relationship that, again, at least in theory, limits the property rights of the trustee and makes the trust agent the servant of the trust beneficiary, in our case being the Native nations. Again, no other group in the US has the legal or political or moral status of being in a trust relationship with the federal government, which President Obama affirmed every year that he was in power when he would meet on the White House lawn with the leaders of most of the Native nations. The Trump administration, on the other hand, has not shown, it's hardly shown any support whatsoever for the trust relationship. And to my knowledge, he hasn't even uttered the word once in his 4 years in office. In fact, several of his actions vividly show that he has little respect for Native sovereignty or the trust relationship or treaty rights for that matter. And this is a fundamental problem, obviously, which is one reason that you see many tribes supporting the Biden-Harris ticket rather than Trump. Now I turn to a sixth concept, and this is one that's very powerful and also very problematic. And this is the bizarre doctrine known as the doctrine of discovery. It was originally devised to head off international conflict over native lands that the colonizing powers, Great Britain, France, Spain, Holland, and others, were hungry for. But over time, it came to also mean that the, quote, discovering nations, the Europeans, actually gained superior legal title. Some even say absolute title to native lands. This is a blatantly racist and ethnocentric doctrine, but it remains entrenched in the law. If you're a law student, or if you have a child who is a law student, if he or she is going to take property law in the first semester of law school, one of the first cases that that student will read is Johnson versus McIntosh, which is a decision that John Marshall wrote, in which he took and talked about and described the doctrine of discovery and how it had limited the land rights of Native peoples and elevated the land rights of the United States government. And this is where we all are mourning the death of Ruth Bader Ginsburg, a Supreme Court justice who did a tremendous amount of wonderful good for many groups, especially in the area of women's rights and feminist theory. But in terms of federal Indian law, Justice Ginsburg had a much more checkered record. In fact, a recent study was done showing that of the decisions that she wrote, about 45% of them supported Native rights, 55% were against Native rights. And one of the decisions that she wrote involved the Oneida Nation of New York State, a case called City of Sherrill versus Oneida Nation in 2004. And in that case, in the first footnote of her opinion, she cited and reaffirmed the doctrine of discovery as a doctrine that elevated U.S. land rights over the land rights of Native peoples. I just read in the recent days of her passing, my wife tracked down a couple of articles in which Justice Ginsburg, before she passed, said that of all the decisions that she wrote, this was the one decision that she regretted the most. And so I was happy to learn of that regret. Although, unfortunately, now we're stuck with this decision until and unless it ever gets overturned. A seventh doctrine, another one that's particularly problematic and maybe the most devastating doctrine yet that the court has devised. This is called the plenary power doctrine, which is also unique to Native peoples. But it also applies, importantly, to Puerto Ricans, as well as to the citizens of the insular territories out in the Pacific. Plenary power, like trust, also has multiple and conflicting meanings. First, it legitimately means exclusive power, so that when you read the Commerce Clause, as I read to you a little while ago, that clause simply affirms that Congress is the sole branch of government of the three branches that has the jurisdiction to deal directly with tribes. States were pushed aside, the executive branch and the judicial branch were pushed aside. This is all solely power, exclusive power that vests in the Congress. And that definition of plenary power, I have no problems with. It has a second definition, however, and this one means that the United States has preempted the field of Indian affairs to such a degree that states are precluded from acting without federal and, I would add, tribal consent. So that whenever the federal government steps in and engages with a particular Native nation, the state is precluded from doing anything without federal consent. And as I said, I would argue without tribal consent. But the term over time also has developed a third, and this is the most devastating definition. And this is the one that is blatantly unconstitutional, in my opinion. It means unlimited and absolute power. This was a doctrine, this definition of plenary power was unleashed in a decision in 1886 by the Supreme Court, United States versus Kagama. And here we need to think about this. We need to think about the meaning that the United States, a constitutionally limited power, has authorized itself to wield unlimited power over native nations and their citizens. Citizens who also happen to be, as of 1924, American citizens as well. Plenary power is still relied upon by the federal courts and Congress when they want to abrogate Indian treaty provisions or when they attempt to terminate specific sovereign powers of tribes, like the effort to force native governments to waive their sovereign immunity or to surrender some of their fiscal entitlements. Such ideas could only be proposed and seriously discussed because some members of Congress, the administration, and the Supreme Court persist in the belief that the U.S. has unlimited authority to restrict or strike native powers of governance. Would those policymakers ever attempt to force states to surrender their sovereign immunity? I don't think so. And even if he wanted to do this, the Constitution would prevent that from happening because states, unlike tribes, have a guaranteed right to exist. Our rights, as I read at the beginning of my lecture tonight from the Wheeler decision, exist only at the sufferance of Congress. And that's where you have the exquisite tension between the concept of plenary power, defined as absolute power, and tribal sovereignty, defined, well, however we define that, right? And this is where we have an uneasy and uneven tension between these two core concepts. So what all the above concepts that I've shared with you, each unique to Native nations, confirms, both positively and negatively, is that Native nations, unlike any other racial or ethnic groups, and this will be my final concept, which I've already touched upon, are sovereign nations, not minority groups. This sovereign status was not delegated to indigenous nations by the federal or state government. It is original and inherent. And while tribal sovereignty, as is now exercised, has certain similarities with the way Western law defines it, it has a political, legal dimension. That is, sovereignty is a relative independence of a tribal nation combined with the right and power of regulating its internal affairs without undue foreign dictation. Such powers include the ability to make laws, to execute and to apply them, to impose and collect taxes, to make war and peace, and to form treaties of alliance or of commerce with foreign nations. But tribal sovereignty also has a different dimension to it, a cultural, spiritual dimension that I mentioned at the beginning when I read to you Vine Deloria's definition. And here's how I define tribal sovereignty. Tribal sovereignty is the intangible, spiritual, moral, and dynamic cultural force inherent in a given tribal community, empowering the nation towards political, economic, and cultural integrity. So, tribal sovereignty, or Lumbiness, or Lakotaness, or Navajo-ness, in other words, is in my mind and that of most natives, the most important of the concepts I've been talking to you about this evening, because it entails the collective soul of each and every indigenous community. It undergirds the way tribal governments relate to their own citizens or enrolled members, to non-citizen reservation residents, to local governments, to the state government, to the federal government, to the corporate world, and increasingly to the international community as well. Native peoples today continue to exercise a good deal of governmental authority, sovereignty over their lands, resources, and the peoples who live and travel through their lands. They work hard to improve the social and economic well-being of their citizens, and they strive to preserve and maintain their unique cultures, languages, and institutions. So with that, I'm going to stop because I see a number of questions that have popped up on the chat screen, and I'm going to turn the floor back over to Mark and have him sort of guide us through the Q&A part.
Absolutely.
Thank you all very much.
Thank you so much, Professor Wilkins. Thank you. Yes, there are a lot of questions here. Let me go through a few of them. And Tom and Bob, do you want to do this part, or shall I get started?
Well,
Go ahead and start, Mark.
Go
Okay.
ahead. Yeah.
Okay. The quote that you mentioned at the very beginning, sovereignty may be erased at any time. Is that from U.S. v. Wheeler?
Yes.
That's from U.S. v. Wheeler. Okay.
Right.
Another question comes from, this is a pretty general question from Katie. She said, one question that I have always struggled with is if tribal law conflicts with U.S. constitutional law, which would prevail?
Well, and this is where we get to the uneven status of native sovereignty in comparison to U.S. sovereignty. The plenary power doctrine that the court constructed in the Kagama decision of 1886 essentially handed to the Congress carte blanche to wield whatever amount of power it wanted to enable the federal government to civilize, to Christianize, to Americanize, to deterritorialize native peoples. And so whenever tribes are facing Congress face to head to head or one-on-one, almost invariably Congress prevails. But when we are faced by states head to head, we sometimes prevail, see, which is what really happened in the McGirt case, right? There you had tribes affirming or arguing that their treaty lands, their reservation lands, had never been formally surrendered by them, and they could find, and Congress could point to no law that had terminated the reservation status, and yet the state of Oklahoma since 1906 had been acting as if it could impose its jurisdictional power anywhere throughout Indian country in eastern Oklahoma. But there, in this case, the tribes were lined up with the federal government, and they were defending the essence of treaty making and treaty power. And so the state of Oklahoma, lost in that decision. So we tend to prevail, well, not tend, we sometimes prevail when there's a conflict between a tribe and a state, or a conflict between a tribe and a corporation. But whenever tribes try to combat or challenge the Congress directly, invariably we get defeated.
Professor Wilkins, on that very point, are there any principles? You said sometimes the courts will, side with tribes. Sometimes they'll side with state governments. Are there any guiding legal principles that the courts use to make those determinations about who wins out between states and tribes when there's a conflict?
Yeah, it tends to be if an explicit treaty right is involved, like it was in the McGirt decision. When there's express treaty language that is unambiguous, and if tribes can focus on that, that really tends to hold them in good stead. Next, if there's a congressional statute which has been drafted by Congress, which says that the state is precluded from doing something, that also works to our advantage. I mentioned the state constitutional disclaimer clauses. Those are important clauses that you find in 10 of the Western states. And they frequently get ignored by state officials because state officials frequently still look to Indian country within their borders as if it's land they have not yet been able to tap into for taxation purposes or for jurisdictional purposes or so on. And yet when you read the Arizona Constitution that was written in 1912, Article 20 of that Constitution says very clearly that the state of Arizona is without any power, any jurisdiction to impose its jurisdictional power or its taxation authority over any Indian or any land within the state. And yet Arizona throughout history, and Bob and I would talk about this when we did our seminars in Arizona on the reservation in Navajo country, Arizona has constantly tried to impose its jurisdiction, and frequently it gets shut down by the US Supreme Court. And so you've got treaty law, you have statutory law, and you have those state disclaimer clauses. Those are three sort of, sets of law that work sometimes to protect the rights of Native peoples.
And just a follow-up here, Joe writes, do state courts handle these disputes between states and tribal nations, or are they disputes that would be handled at the federal level?
It depends on what the issue is. It depends on what the crime is. It depends on the race of the parties. It depends on where the offense took place. The area of criminal and civil jurisdiction is very complex. I don't know that I included a handout about that, but I could get a handout and get that to Mark, and he could put that up, a little table that identifies whether it's a state or the tribe or the federal government that has jurisdiction under what conditions. And so that's what they're trying to work out now, right? Because of the McGirt decision, they're trying to sort out how they're going to deal with the ramifications of that decision. But it's very complicated. In the area of criminal law, by and large, if it's a major crime like murder or rape or assault with intent to harm, that is a federal offense. And only the feds have jurisdiction. Sometimes the tribes can also exercise jurisdiction. States are precluded. But if it's a minor offense, and depending on where the crime occurred and what the race of the parties was, it all depends.
Well,
that's the short answer. I will try to get a handout and get that to Mark about that.
Well, in the case of a conflict between states wanting something and tribes wanting something, for example, the most common is a gaming license. Mm-hmm. For example, I'm from Nebraska, and I know that there's tribes in Nebraska that have wanted casino gambling and pushed for it for a long time and have been unable to do it yet, and Nebraska's been able to stop that. And yet in Florida, the Seminole tribe was successful. Yeah. And it doesn't seem quite fair that those kinds of issues would be resolved in state courts when the state has a vested interest, so to speak.
Yep, that's a very good point. In fact, when the Gaming Act was enacted by Congress in 1988, it was another one of those compromise pieces of law, because states were now given a say-so. And they never had that before, right? I mean, if the state of Arizona wants to have a corporation come into its borders, it doesn't have to get the tribe's consent to do that. And yet, as you pointed out, in Nebraska and in Utah, tribes in those two states are denied the right to do that because the states don't want that. And so there's a fundamental unevenness to the status of Native peoples, and it was all initiated by that law. And that just shows, and that's where the issue of federalism, because it's such a malleable framework, right? Sometimes states are in the ascendancy, and sometimes they have people in power at the federal level, and they're able to write laws that benefit the states more than it benefits the tribes. Other times it's the opposite. And in terms of the Gaming Act, it's been very difficult because once the Supreme Court heard a decision involving gaming, there was a Supreme Court decision in 1996 involving, in fact, the Seminole. The Seminoles had sued because they wanted to expand their casino or something. The state of Florida didn't want that to happen. And yet the gaming law of 1988 specified that tribes had the right to file a lawsuit if states, stonewalled. And yet when it went to the Rehnquist Court issued a ruling that said, no, states have sovereign immunity and they can't be sued without their consent. And so that stopped tribes from being able to challenge what the state was doing to them. And so it's that uneven tension, right, between the federal government and the state governments. And sometimes the federal government upholds the treaty status of tribes, and sometimes it upholds its relationship to its constitutional partner, the states. and it's you just never know which way it's going to play out.
Bob?
I've got a question. I'm interested, David, in some discussion about tribal governments. As you know, some have their own constitutions. The Navajos decided not to. They do have a Bill of Rights, but they do have a legislative branch and a president and a Supreme Court. How does that vary among various tribes in the nation?
That's a good question. In fact, one of the handouts that I asked Mark to upload is a short page that gives you some sense of the amount of governmental diversity that you find in Indian country. I mean, from the time I joined the Academy back in 1990, I've been collecting tribal organic documents. And with my wife's help, we've got a constitution database that over 500 tribes, about 505 more or less, now operate under constitutions out of the 574. But that means that there are 70 tribes that don't have constitutions. Like you mentioned, Navajo, they operate under a simple code that began in 1938 that they just expanded over time into a 4-volume, set of ordinances and so on. Other tribes operate under a simple set of articles of association. Other tribes operate under what they call customs and traditions. My wife and I interviewed the leaders of a very small tribe in California last summer. The tribe has 10 members in the nation, and yet they're a federally recognized tribal nation. They've never had a constitution. They don't even have a set of bylaws. They just operate based on the concept of kinship. They're all related to one another, and they take turns being the leader of their small tribe. And so there's a tremendous amount of diversity in the types of governing arrangements that tribes have. I'm right now writing a book that Oxford's going to publish, hopefully within the next year and a half, 2 years. It's my big book on Native governance. So when I get that out, Bob, I will see that you get a copy.
Well, thank you.
Because I want to cover all the great variety of ways in which Indigenous peoples govern themselves today. And there are some fantastic, ways in which tribes continue to govern, although the constitutional framework has become the dominant structural arrangement that most tribes now operate under.
David, we have a quick comparative question that kind of goes along with this. And the question from an anonymous participant is this: can we learn anything from other nations with indigenous populations and how they've worked out relationships and so forth? Is there any, I guess another way to say it, is there any good example out there of those kinds of relationships? That's
a great question. I teach an introductory course. It's called Intro to Indigenous Peoples: A Global Perspective. And I study what's happening with First Nations and Inuit and Métis in Canada, our situation here, Indigenous peoples in Latin America. And then I go out into the Pacific and I look at what's happening with the Aboriginal peoples in Australia, the Maori in New Zealand, the Ainu of Japan, the Sami of Northern Europe, Norway, Sweden, and Finland. And then we talk about these broad comparisons. And it's quite fascinating because a number of Native peoples around the world are really beginning, since the 1960s, there's been a great surge of international activity. There's been much more happening internationally than there has been domestically on Native rights and Native governance. And the Maori community in New Zealand have really made great strides in reasserting. They only signed a single treaty with the state of New Zealand in 1840, the Treaty of Waitangi, but they've been able to parlay that single treaty into getting the state of New Zealand to recognize their rights in a way that's more powerful than what we have here. Up in Canada, you have a situation where the several hundred First Nations, they were able to get the Canadian government to, when they went through a constitutional reform process, Canadian Aboriginal rights are now enshrined in the Canadian Constitution. In Latin America, a number of states, including Bolivia and Guatemala, Mexico, also have constitutional amendments that provide, clear, explicit recognition of Aboriginal rights. In fact, right now, just this very day, I'm writing an article about a possible suggestion that we need a constitutional amendment in the United States if we're ever to have any kind of security for our rights. Because as I said, right now, everything is based on the rule of person, not the rule of law, because the Trump administration and Trump himself can single-handedly, open a pipeline and make that happen. He could terminate a tribe tomorrow if he wanted to do that with Congress's consent. The Supreme Court, by the slender reed of a single vote, could terminate a tribe. So we have no guaranteed status, which that quote I read that Clarence Thomas said in the Laura decision. Not that the constitutional amendment alone will protect us, because even Canada, with their rights constitutionally enshrined, they still face all sorts of problems with the Trudeau administration. It's going to take, and this is where I really laud this very effort that we're engaged in tonight, we the people, right? Education, educational curriculum, and trying to get the word out in a way that is actually rooted in history and shows what actually transpired. We need educational curriculum from K through 12 on into college and beyond if we're ever going to find a way to stabilize and bring clarity to the situation with Native peoples. But since the 1960s, when international affairs took off, Native peoples have been traveling abroad, and they brought back lots of those ideas. So that in Norway, Sweden, and Finland, in those three countries, the Sami have their own parliament that sits alongside the regular parliament of the state. It's largely an advisory body, but at least it's there, right? Giving some advice. It may not always be listened to, and the Sami still have battles with the parliaments, but at least it's an established, institutionalized mechanism that gives them a measure of representation that we don't possess right now in this country.
David, can you talk a little bit about the Indian Civil Rights Act of 1968? Does that help, hurt, or have no difference in terms of what you're just talking about in terms of security?
Yeah, that was a major law. It was actually instituted by some Native individuals who were complaining that their own tribal governments were violating their individual human rights and civil rights. And so they approached Senator Sam Ervin and said, we're tired of being mistreated by our own government. And aren't we US citizens too, right? And so Senator Ervin held a series of hearings. Byington Delory testified at one of them in 1961. And ultimately, when the Indian Civil Rights Act was passed in 1968, they took several of the first 10 amendments and wrote statutory versions of those and made them applicable to tribal governments and tribal courts in particular. That was the first direct imposition of some elements of US constitutional law into Indian country. And some Indians embraced that act. Other Indians challenged it, and they said, you have no right to impose your constitution on us. And yet it was one of those mixed bags where some Indians were thrilled that maybe they would finally have some way to protect their rights against their own government. The problem with the Indian Civil Rights Act, if you're one that supports its presence in Native life, is that the only remedy is a writ of habeas corpus, right? Which means you have to be literally in a tribal jail before you can, invoke it. And most federal courts have decided that they don't want to go behind what tribal governments have done. And so they turned a blind eye. And so it's sort of been declared to be, a law without a real remedy. And so it sometimes works on a local level, but it hasn't provided the kind of protections that some natives want. On the other hand, natives feel good because they've been able to keep out most of the US Constitution from further impinging on their rights.
Professor Wilkins, has there ever been, you mentioned in your presentation, your excellent presentation, that you know, Native Americans were only mentioned a couple times in the Constitution. And then we have these series of Supreme Court decisions and court decisions that are kind of all over the map. And tribal sovereignty is ill-defined in the United States. It's various, and has there ever been a movement, or maybe it's antithetical to tribal sovereignty, to have a constitutional amendment that would officially and formally recognize the sovereignty of tribes, and it could be short and sweet and to the point, and away we would go. Has there ever been any talk of that?
Only a handful of academics have talked about it. There's never been a major push at the national level for that. Vine Deloria mentioned it early in the 1970s. Then there was a book written by two scholars in 1980 called The Road by Russell Barsh and James Youngblood Henderson. And they had a two-page elaborate constitutional amendment that they thought might provide some actual protection and congressional representation for Native peoples. It went nowhere. More recently, there was a book written by another non-Indian law professor, Frank Palmersheim, a book called Broken Landscapes, in which he proposed a very short, very succinct, but very pithy constitutional amendment that he thought would bring some clarity and some stability and some protection for Native treaty rights and sovereignty. But again, it was just an academic exercise, right? It was a book that he wrote. The one thing that had made more progress, at least until 1905, was the idea of statehood for Native peoples, right? I mentioned the Delaware Treaty of 1778. That was the first talk about it. But then there were other attempts throughout the 1800s, actually, culminating in 1871 in Oklahoma, where members of the 5 civilized tribes adopted a constitution, and they were encouraged to do that by federal lawmakers. And there was some serious talk about statehood, but that sort of fell away. And then the last major push was in 1905, also again in Oklahoma, with members of the 5 civilized tribes, in which they drafted a 48-page constitution, and they were going to create what was going to be called the state of Sequoia. And of course, by 1905, most of Oklahoma, especially eastern Oklahoma, more and more non-Indians had moved into Indian country, and they were animating for statehood for Oklahoma. And so you had both these states that were both pushing for statehood simultaneously. The Indian idea got pushed aside, and Oklahoma emerged. And yet the Oklahoma Constitution, they actually drew great chunks of their constitution from the Sequoia Constitution that the Native peoples had drafted. And since then, it hasn't really been talked about. I remember seeing an academic article in the 1970s that someone wrote about the Navajo Nation, calling for the Navajo Nation to become the 51st state, right? Navajos are the largest tribe in the country, over 300,000 members. Their land's 25,000 square miles of territory. And they meet all the requisite, and yet we can't seem to gain any traction. But it's an idea. And the idea of a constitutional amendment, that's, like I said, that's an article I'm writing this very moment for a journal about ways to amend and make the US Constitution more humane, more fair, more just. And I'm not convinced that a constitutional amendment would do that for us, given the number of Native nations, given the tension between states and Native peoples. And yet I think the combination of that and additional further international recognition, the combination of the two forces working simultaneously would probably bring some relief to Native peoples, I'd like to believe.
David, you might recall when we were in Chenli on the Navajo and the Navajo Nation, Chief Justice Herb Yazzie spoke to the group, and he talked about his conflict of Western law being piled on top of, for lack of better words, indigenous law, and that something that came out of that was well, I guess it didn't come out of it, it had always been there, was the peacemaking system as a different way of dealing with justice. Right now, we have some big time issues of justice going on around the country. Can you tell us a little bit about the peacemaking system?
Yeah, in the Navajos were one of the first tribes to adopt the peacemaking process. And what they did was essentially reach back into their own cultural past and bring forth those traditional ways of resolving disputes that weren't based in adversarial proceedings, right? They bring elders in, they bring respected individuals in who serve as mediators. And they basically talk things out until they get resolved without having to go to the Navajo Nation court system. The Navajo Nation have one of the most sophisticated court systems. They have their own Supreme Court, they have appellate courts, they have children's courts, they have a number of court systems. And yet their court system has been overwhelmed, and most Navajos, even if they go through the court process, don't feel that justice has been served. And that's what prompted the peacemaking process that the Navajo Nation started. And they now have the most sophisticated peacemaking process, and other tribes have looked to them and are modeling their peacemaking process on what's happening in Navajo country. And there's a lot of good literature that's been written about that. One of the authors is a guy named James Zion, Z-I-O-N. He's written quite a few articles, a couple of books, along with some Navajo Supreme Court justices too, who have retired and have joined him as co-authors. And so there's a lot of literature that's out there, and more tribes are beginning to turn their attention slightly away from the adversarial process back to the more mediated process that works so well for Native peoples historically.
We have a question from the president of the Center for Civic Education, no less. One of last week's presenters. A little bit lengthy, but I think it's worth hearing your thoughts about. Christopher Riano says, David, I'm very curious to hear your thoughts. At times, sovereign nations have been far ahead in civil rights, like the marriage equality movement. And in other arenas, as there has been significant interference from federal and state governments, like the regulation of gaming and alcohol. Why do you think the areas of criminal law and special regulation are the usual place in which so much conflict arises between sovereign nations and federal and state governments, as opposed to individual rights and liberties?
Oh, I don't know. I mean, crime. I mean, we see how the Trump administration is taking this concept of law and order, to the nth degree, right? Trying to use it as his cudgel to try and force his way back into the White House to get reelected. But we certainly know that in any country, crime has gone up exponentially in the last 20, 30 years. The issue of murdered and missing Native women is at an astronomical heights. Native women around the country, both in the United States and in Canada, are being murdered and are being kidnapped and taken and treated as sex slaves on a scale that is unfathomable to most Americans. But it happens all the time. And crime in general has just skyrocketed, in part because there's jurisdictional anarchy in many parts of the country because of laws that Congress has adopted, but doesn't always enforce, doesn't always properly fund. We have a Department of Justice that can barely keep up with crime in other parts of the country, and yet they're supposed to police the Navajo Nation with 25,000 square miles of territory, and yet it's underfunded. And so it's an ongoing, and it's a huge and massive problem. And Public Law 280, another law that Congress adopted in 1953 that gave 5 states criminal and civil jurisdiction over the reservations in the country, that has caused nothing but chaos in terms of crime and getting crimes dealt with in both criminal area and civil jurisdictional area as well. And so we have lots of problems in the area of criminal law and civil law that have never been resolved, in part because the federal government wants to have the cake and eat it too. States want to be able to control and dominate any country without providing any resources to that effect. And Indian people just want to be left alone to take care of their own affairs, but they're not allowed to because of constant interference from the federal and the states and the corporate world. So it just makes for an absolutely chaotic situation. And it's just, there's no simple solution to it until and unless we can find a mechanism like the revival of the treaty process, which would enable tribes to be able to negotiate a new political arrangement with the federal government that reflects who they are right now, not who they were in 1855 or 1871 or 1823, but right now. Right now we're stuck, we're sort of frozen in time. We have treaties that date back into history that are still good law, and yet we're not who we were in 1871, are we? Things have changed, we've grown, our population has just skyrocketed, and yet we lack the resources. And even though the federal government has a treaty and trust obligation, it fails to provide the resources that they are constitutionally pledged to provide for. And states are reluctant, and they still find ways to diminish the vote, to deny the Indian vote, to challenge Indian vote. And so it's a constant tug of war. And unless and until we can find some way to find some common ground and a set of mechanisms and structures that are based on respect and fairness and justice, we're going to continue to have all sorts of problems.
But on the individual rights side, it is true, isn't it, that tribal members can, because they're also obviously United States citizens and citizens of a state, as you mentioned during your presentation, they have every right to make rights claims against state or national or local governmental officials, and that happens. But what about making claims against tribal governments? Is that ever possible? You know, that I'm a U.S. Citizen, or I'm a citizen of Arizona or whatever, and I'm saying that my tribe is violating my individual rights somehow. Is that possible or not?
Yeah, oh, it is. And that's where the Indian Civil Rights Act, that was designed to provide those sorts of individuals protections, right? Some guaranteed way to have their rights heard by a tribal court. And then if it didn't work out in tribal court, they could appeal it to a federal court, right? But in 1978, the Supreme Court handed down another decision, Santa Clara Pueblo versus Martinez, in which a Pueblo woman had married a Navajo man. They lived within the Santa Clara Pueblo, raised their children within the Pueblo. They were culturally Pueblo. And yet when the parents took their children to get them enrolled in the tribe said, we won't enroll your children because you married a non-Pueblo member. And she said, what? That's not right. My children are in fact Pueblo. I'm Pueblo. My children are who I am. Just because they happen to have a Navajo father, that doesn't diminish their Pueblo identity. And so she filed a lawsuit under the Indian Civil Rights Act. And yet Justice Thurgood Marshall, who otherwise generally wrote outstanding opinions, wrote an opinion in this case which pitted the sovereignty of the Santa Clara Pueblo against the individual sovereignty of Ms. Martinez and her husband and her children. And what he said basically was that the decision on who is enrolled in a Native nation is not ours to decide. It's the decision of the tribal government. We can't hear your complaint, Ms. Martinez. And so she was shut down. And since that decision, most Indians who've had their human rights violated, especially when they've been kicked out of their tribe, if they've been exiled or banished or disenrolled, the Supreme Court has cited back to the Santa Clara case to say that we can't hear your case because the tribe has sovereign immunity, and we can't, we're sorry, even if we agree with you, we're not going to support you because we have to respect the sovereignty of the tribe. So there, the tribe's sovereignty was upheld, but the individual civil rights of Ms. Martinez and her family were violated. And that's caused a tension that has not yet been resolved in the law either.
I might add that law code of the Pueblo did not apply to men.
Right.
if a Pueblo man married a Navajo woman, their kids could be citizens.
Right.
But the women, if they married outside the tribe, could not. That's a very interesting case. I think Katie mentioned something like this earlier on. I use that a lot in my teaching of this because it pits up individual liberty of women against tribal sovereignty. And
Right.
who wins? Who wins? It's a tough one.
Yep. Yep. That's true.
I think we have time for maybe one more question. Tommy, you got anything? Mark?
There are so many good questions out there. Let's see. Alyssa asked, do you have a sense of whether there might be a movement to bring a case that would allege a violation of social, economic, and cultural rights of Native peoples in order to help preserve Native sovereignty in case law?
Huh. I'm not quite sure how to deal with that question.
I think that, there's the contrast between, the constitutional issue, maybe a constitutional amendment, and maybe case law, which might, I don't know, which might, there might be something that could.
Well,
preserve
there
Native
would,
sovereignty.
we could at least conceive of ways, Professor Wilkins, of the court, maybe through equal protection, maybe through substantive due process, developing some sort of system for carving out some piece of constitutional law that was specific to Native Americans and tribal sovereignty and so forth. And to my knowledge, that has not happened so far. It's not its own level of scrutiny on the due process clause, or it is individually a race-based classification. So any state or federal action that that is based upon your status as a tribal member would receive strict scrutiny. But as you mentioned, and that's the tricky part, is that Native Americans are different and unique than any other group inside the United States. And by the way, we had a question about citizenship for the American Samoa case. I'm not sure if you're familiar with it or not. Basically, I think it's still under review, and panelists help me out here if I'm wrong, but it's basically that whether or not, the definition of citizenship that was provided in the 14th Amendment should embrace American nationals. And so instead of their status as American nationals, they would be considered citizens and so forth. Which is also another thing that we, the people teachers, talk about all the time. In that citizenship clause, under the jurisdiction of, in the 14th Amendment's definition of citizenship. And I think there's pretty much consensus now that that was meaning excluding Native Americans.
Yeah, we were not counted at that. In fact, right after that amendment was adopted, the 14th Amendment, the Senate Judiciary Committee issued a report in 1870. And it was an elaborate, very detailed report. They went through all the existing case law, a lot of treaty law, and so on, and said, look, this amendment can't apply to Native peoples because they are still outside of the constitutional framework. Until and unless we get their consent or they agree to come within the body politic of the United States, our amendments can't apply to them because they have their own governments and they are not constitutional entities. So yeah, exactly.
David, you've got a couple minutes here. We want to make some kind. Well, first of all, is there any good news?
Well, the good news is that I was shocked when the McGirt decision came down the way it did. I really thought we were going to get slammed by that. I thought Ginsburg was not going to support that, given her recent trend of cases against Native peoples. I knew that Gorsuch was probably going to be the one assigned to write it, and he's shown already in his short tenure on the court that if a treaty if explicit treaty language of an Indian tribe is involved, he's going to cite that language and he's going to interpret it the way the Indians would interpret it. And so far, he's rendered at least 3 or 4 very good decisions that have upheld indigenous treaty rights. And so, I don't know about him in other areas of law, but in the area of federal Indian law, he's been a good figure so far. So he and Sotomayor, they're the 2 votes that, I can pretty much count on when it comes to the enforcement of treaty rights. Kagan, on the other hand, is a little bit slippery, and Ginsburg had always been very slippery. So I don't know who this next appointee is going to be. So it could be very, very, very dangerous for the next period of time if Trump's nominee goes through in these next couple of months.
Thank you very much, Professor Wilkins. We are out of time this evening, but this was a very engaging discussion as shown by the tremendous response in the chat and in the Q&A. I just want to mention to everyone that we have another webinar next week. In fact, for the next several weeks, leading all the way up to the election, the week before the election. Our very next one is with Lisa Tetreault. She's an associate professor at Carnegie Mellon University, and this is The Power of Movements, the Struggle to Pass the 19th Amendment and Beyond. It is the 100th anniversary of the ratification of the 19th Amendment. So stay tuned for that one. That's sure to be a good one. And I want to thank our sponsors. Thank you so much to the Center for Civic Education, Kansas State University, the Johnson County First Amendment Foundation, and the Indiana Bar Foundation. Once again, without you, this webinar would not be possible. Good night, everybody. Thank you so much for joining us tonight. Good night.
Thank you, guys. Take care.
Thank you.
Good night, David.